I am now recording the class. So we were talking about the story structure and the logos and the pathos together. And so now we're going to talk about logos and pathos together at an even larger scale, because last week we were just talking about logos and pathos using logic to improve emotional appeal. And we were talking just really about the statement of facts, although you can certainly apply those same principles when you're dealing with an illustrative narrative, either in a parenthetical or in a rule explanation type paragraph. You can use some of those same principles, although obviously, because legal writing is generally time-pressured writing, we don't really have time to think about in depth the story of each of those illustrative narratives. On top of that, at the point at which we use the cases for the illustrative narratives, the story has really already been constructed for us, and so we don't want to reconstruct that story. So although you can use it for illustrative narratives, you don't as much. So now what we're going to talk about is using logos and pathos together on a larger scale. And we're going to talk about using the statement of facts section. Once you've constructed that narrative, you constructed that compelling story, using the entire statement of facts to prime the entire argument. And so up until now, we've talked about priming within just a single section, primarily the statement of facts. And we've talked about, we've used priming a little bit with regard to logos when we talk about door in the face and foot in the door. Those are priming techniques to get your reader ready to understand or ready to accept your more critical request. And so priming, of course, is anything you do to sort of soften the ground for your reader. So we've talked about priming within the statement of facts. We've talked about priming within the argument. And now we're going to talk about using the entire statement of facts to prime the entire argument. And the first thing that we're going to do to sort of prime our topic is to look at these two cases, or really the excerpts of cases, the Broomfield and Clark, to get a sense of how important story is to courts. And so Broomfield and Clark both came out last summer, and they came out late June, early July. And they were really interesting cases because they are consecutive in the reporter. And so Broomfield came out first, and then the very next decision that the court announced was Clark. And in Broomfield, as you guys have seen, Justice Thomas and Justice Alito, along with some other justices, dissented. And Justice Alito excluded himself from part of Thomas's dissent. And so what was the reason, anybody who wants to answer, that Alito exempted himself from that one portion, section 1C, of Thomas's dissent? Yeah, Marilyn?
Not sure if this is correct, but was it because he wanted to tell the story because it was a compelling story? He wanted to tell the story.
When you say he, who do you mean?
Or Justice Alito.
Okay, so Justice Alito's objection to section 1C was what again?
I'm sorry, I'm wrong. I'm wrong what I was thinking.
Okay. Anybody, why did Alito... Yeah, Joan.
Alito was not in agreement that the story, that the emotional appeal to the story was part of the majority's legal reasoning.
Right. And so, yeah, so Alito had what to say about the use of this story?
He said it was not essential to the legal analysis in the case.
Right. He said, listen, we are about the business of legal analysis. And this story, while a compelling story, and while certainly it could be helpful to someone who reads it, is not part of what we do. What we're doing is the legal analysis. And this story wasn't part of what the majority relied on. And it's just not, this story's not important. What was the story about? Anybody? Yeah, Marilyn?
The story was about a football player who had his family murdered, or actually his parents murdered, and he ended up raising his siblings. Mm-hmm. And then he just went on and on about what he accomplished despite his beginnings, mm-hmm. and was trying to contrast it with this defendant who was actually using it as an his background, disadvantaged background, as an excuse for what he did.
Yeah, so Thomas's point was, listen, the majority found the background compelling, and arguably Thomas's use of that story was legally relevant, because Thomas was saying, listen, the majority said they found compelling the defendant's background. And so, if you want to talk about background, let's look at somebody who came from a similar background, who became a philanthropist and a professional athlete. So clearly background is not determinative. Now, we can argue about whether that's a fair comparison, and about whether becoming a philanthropist and a professional athlete from that kind of background is typical, or something that's an equally available path. But the point is, I think it's a fair point to say, for Thomas to say, this is legally relevant. If the majority considered the defendant's background, then I ought to be able to say, well, listen, here's a similar background story that went in a completely different direction. So the background doesn't explain everything. So arguably Alito is wrong there. Arguably Alito is incorrect. Now, of course, the story is all the more compelling because it compares the defendant to the victim's son. And so, the victim's son has the additional hardship at the hands of the defendant. And so it makes it really even, it packs all the more punch for that reason. And so, so there's no doubt that it's a compelling story, and Alito certainly says that. Why do you think Alito responds the way he does to that then? Because arguably it is legally relevant. Why do you think he responds that way? He responds strongly enough that he's willing to join in the dissent, but not be part of that one story. Rand.
I think one of the major concerns that Alito has is that a lot of judges put in their personal beliefs into decisions, and he wants to make sure that it's not misconstrued by anyone, that he did make a note saying that some part of this, though it may be legally relevant, if someone takes it the opposite way, mm-hmm. he was trying to put it out there for the judges that not all of us agree to the fact that it was legally relevant, and that it could become an idea of like a personal perspective of the judges.
So better to leave it out.
Yeah.
Yeah. Marilyn?
I was thinking maybe he just felt that the pathos part, the emotional part, was too strong, and it took away from the legal argument instead of adding anything to it.
So it was just too much.
Too much, yeah. Too heavy-handed.
Okay. So with all that as context, let's look at Ohio versus Clark. And I had you guys just read the first part of it, of the actual decision, not the syllabus, but of the actual decision. And so, actually, I should have had you read and let me make a note for myself. I should have had you read the first two paragraphs. But it's fine either way. So we've got this first paragraph. Now this is Justice Alito's decision, and it comes out the very same day as his decision in which he disagreed with Thomas's dissent. Darius Clark sent his girlfriend hundreds of miles away to engage in prostitution and agreed to care for her 2 young children while she was out of town. A day later, teachers discovered red marks on her 3-year-old son, and the boy identified Clark as his abuser. The question in this case is whether the Sixth Amendment's Confrontation Clause prohibited prosecutors from introducing those statements when the child was not available to be cross-examined. So it's a Sixth Amendment / evidentiary issue. But his first shot out of the gate is Darius Clark sent his girlfriend hundreds of miles away to engage in prostitution and agreed to care for her 2 young children while she was out of town. What relevance does that have, if any, to the Sixth Amendment claim? Anybody? Is that legally relevant information, Marilyn?
I don't think it's legally relevant, because if you left it out, you would probably still come to the same conclusion about later on.
Yeah,
it's telling.
The reason that the child was alone with Darius Clark is irrelevant, right? The question is, does Darius Clark have a right to confront his accuser under particular circumstances? So what's relevant is really the outcry, right? Those of you who've taken evidence, you talk about outcry witnesses. What's relevant is the outcry. To whom did he tell the story first, and under what circumstances? So this is irrelevant. If you look at the next paragraph, and again, I know I didn't ask you guys to read this, but I think it's relevant that this is the first paragraph once he gets past the introduction. Darius Clark, who went by the nickname D, lived in Cleveland, Ohio with his girlfriend TT and her 2 children, LP, a 3-year-old boy, and AT, an 18-month-old girl. Clark was also TT's pimp, and he would regularly send her on trips to Washington, D.C. to work as a prostitute. In March 2010, TT went on one such trip, and she left the children in Clark's care. Most of that paragraph has nothing to do with the Sixth Amendment, right? But what impression do we have of Darius Clark after the first 2 paragraphs? Anybody? What impression do you have? Yeah, Rayanne?
He's kind of a scumbag.
Yeah, he's a dirtbag. This guy's not nice. Joan?
I thought he's a pimp.
He's a pimp, right? Right. He's a dirtbag. He's a dirtbag and he's a pimp, completely independent of one another. He is a pimp who is a dirtbag and a dirtbag who is a pimp. There's ample evidence that he is each one of those things independent of the other. He's not a nice person. And so what was the purpose of including this information by Justice Alito, who has just said in a previous opinion, listen, I don't like the stuff that's not legally relevant. I'm not a big fan of that. So why did he do it? He went out of his way to say, I don't agree with the extraneous emotional information that Justice Thomas went out of his way, went on the record to sort of scold his colleague for being overly emotional. Then why did he do it? Loretta?
Maybe because this involves abuse of a child, of a 3-year-old.
Well, the other one was, it was a cop murder, wasn't it?
Yeah,
I mean, the only thing that's on par with abuse of children is murdering cops.
Okay.
So why do it, Marilyn?
I was thinking that a Sixth Amendment issue
Mm-hmm.
is not compelling enough alone, and people may not care about it enough, maybe in his mind, without making it compelling and adding all that extra stuff in.
Well, okay. Have you guys read boring Supreme Court opinions?
Yes.
Why did you read them?
Because I had to.
Exactly.
No.
Yeah, the Supreme Court doesn't have to be interesting. You have to read the Supreme Court, right?
Right.
So why do it? Why do it? Rand?
I'm thinking it because it personally got to him. I think that what happened with the child, he might have children of his own, and sometimes when it comes to being in the same or similar circumstances, you want this guy to look bad. Whereas he couldn't relate to the kid who became the entrepreneur who came out of a bad situation. So maybe because he could relate better, he wanted to relay more of his personal feelings towards the situation.
Okay, so maybe he was hooked in. Joan?
Maybe he thought it was legally relevant.
Okay, so maybe he thought that was, maybe when he wants to do it, it's legally relevant,
Relevant.
right? When it touches me, it's legally relevant. So what can you, from this limited pool of evidence, what can you, this is a question for anybody, what can you deduce about the value of the emotional narrative? Judges say they don't like it. Yeah, Joan?
It can go either way.
It can go either way. You do. That's absolutely one of the points that you want to get from this, is that you do have to be careful that even that when it's important to the individual author, it can seem a lot more valuable. And so you do have to be careful about that for sure. You want to be careful not to go too far, because clearly I think you guys are onto something with the with Broomfield. That really clearly touched a chord with Thomas in a way that Clark touched a chord with Alito. But either one could be criticized for going a little bit too far. What else can we deduce from this? Would it be fair to say that even though one might be criticized for using an emotional appeal, it is effective? That Alito maybe used it not because he thought it was professional, but because he knew it would work. Ryan?
I was just going to say, you got to know your audience, right?
Right.
You got to know who's reading it, and if you think it's going to affect somebody emotionally, then you should talk about it.
Yeah, absolutely. And the other thing is, you may have heard this phrase, you may not have heard this phrase, that you can't get the skunk out of the jury box. You guys heard that one? And what it refers to is once an audience has been exposed to information, they can't unknow it. Once they know it, they can't unknow it. And so as much as you may try to put aside the fact that Darius Clark was an unsavory character, it's going to be really hard to do, and just as it may be hard to put aside, or just as you may feel like it's not relevant that the victim's son made this wonderful life for himself, it's going to be hard to put that completely aside. There's no way to get that out of your brain once it's in your brain. And so, and what's interesting is if you look this opinion up online, there's no reason you should have, but if you looked it up and went through the whole thing on Broomfield, you would see that Alito included a photograph in his dissent of the victim in her uniform, which is also it's incredibly compelling. It's incredibly compelling. So even judges like Alito who say that they don't like the appeal to emotion, they still use it. And the reason they still use it is because it works. And so the two things that I hope that you get from Broomfield and Clark is that, one, it can go too far, and you want to be careful about that. But two, it does work. It's very effective to be able to paint somebody in a particular light. Alito's opinion in Clark is also an example of what we're about to take a look at with regard to Shuttlesworth and Walker, and that is the priming of the argument with the facts. And so he takes his factual theory, which is his factual theory is basically Darius Clark is a scumbag. And the scumbag has had his Sixth Amendment rights allegedly violated. And so they fit together very nicely. Darius Clark is a scumbag who alleges a violation of the Sixth Amendment right. We find no violation. And so you're primed for that conclusion by the way the facts and the argument fit together. Okay, so we're going to take a look now at Shuttlesworth and Walker. And so a couple things I want to point out as we go through this, or that I'll ask you as we go through it. First of all, as you read those first 4 or so pages of Shuttlesworth and Walker, did you notice the dates? Did you notice the dates of the opinions? Yeah, Marilyn?
Yeah, I noticed that there were 2 years apart, 67 and 69.
Right. And did you notice the relationship between the two cases?
Same city?
Same city.
Mm-hmm. And they were about demonstrations and civil rights protests.
They were about similar. Yeah, they were about protests. Nicole?
I noticed that Walker referenced Shuttleworth, or it might be the other way around, but one referenced the other, which made it a little confusing as I was reading it.
Okay.
Just because it seemed like the facts were identical.
Mm-hmm.
But then it was 2 different decisions, and the petitioners were different people. So, and the story was described like in wildly different ways.
Yeah, and different legal theories also.
Yeah.
Yeah. Okay, and that was confusing, right?
Yeah.
As well it should be. So both of these cases arose out of the Good Friday Parade, which was a civil rights protest in Birmingham, Alabama. And Shuttlesworth and Walker were participants in that parade. And so the reason the facts seem so similar is that it was the identical incident. Shuttlesworth and Walker were both participants in the incident. And I believe they were both pastors. I know Shuttlesworth was. I believe Walker was too. This is also, for those of you who have ever read Martin Luther King Jr.'s letter from a Birmingham jail, this is the same protest that Martin Luther King Jr. was arrested for, and it was while he was in jail that he wrote Letter from a Birmingham Jail. And so these 3 men, King, Shuttlesworth, and Walker, were all part of the leadership involved in this single protest called the Good Friday Parade. So the dates of the respective opinions are 1967 and 1969. Looking at other similarities, did you notice who authored both of the opinions? Anybody? Who authored each of these opinions? You, son?
Justice Stewart.
Yes. So Justice Stewart authored these 2 very different opinions on the identical situation 2 years apart. So you had Shuttlesworth and Walker both arrested. It took Shuttlesworth's case longer. No, sorry. Yeah, it took Shuttlesworth's case longer to reach the Supreme Court than it did Walker's. Walker got there first in 67, and then the other one was in 69. So, Nicole, you said that that they were really wildly different stories. And so let's look at that. How do you mean they were wildly different stories? So, for example, what was the story in Walker, the first case?
Let me just make sure I'm looking at the right one. In Walker, it was about a group of pastors leading their parishioners on a walk to protest civil rights situation in the city of Birmingham. But the way it's described is very orderly.
No, you're looking at Shuttlesworth.
Oh, sorry.
What was it like in Walker?
Oh, Walker had more descriptions of the Birmingham complaint than Shuttlesworth did.
Okay. So Walker took its facts primarily from the city's case. That they took the city's complaint, and there's this huge block of facts that they just lifted directly from the complaint by the city. And in that complaint, how was the protest or the protesters described?
They described it as like an unruly crowd that also inspired bystanders to group behind them, creating an even bigger crowd that blocked the street and were violent and assaulted police officers. So just a picture of disorder and chaos and like bad citizenry.
Yeah, and so, bad citizenry. I like that. Nikki, what else?
I think they even said they were threatening. Maybe I'm confusing this or misinforming, but I thought they said it was threatening and then threatening like the peace and the order of everything.
Yeah, and so if we look at some of the specific language on that first page, starting with the quote. First of all, here's something I want you to notice as far as the structure of the story. Remember, we talked about perspective last time. We talked about starting from your protagonist's perspective. So the court's protagonist here is going to be whoever wins, right? On Wednesday, April 10th, officials of Birmingham, Alabama filed a bill of complaint. So they don't start back with the protests. They start with the bill of complaint, which is where the city of Birmingham began to take action. So they start from the perspective of their protagonist, the city of Birmingham. And then it says they asked for injunctive relief. The bill and accompanying affidavit stated that during the preceding 7 days, and then they lift language out. This is incredibly effective to lift this language out of the complaint. First of all, it endorses the city of Birmingham. Second of all, it makes it sound like the court is we're just telling you what happened. We're not putting a spin on it. Here's exactly what the complaint said. So it sort of takes the court's fingerprints off of it while still endorsing that view. And let me focus you on some language. About halfway down, you see mass street parades. So street parades doesn't sound so bad. Mass street parades starts to sound a little bit more intimidating. Trespasses on private property. After being warned. Congregating in mobs. Unlawfully picketing private places. And then below, calculated to provoke breaches of the peace, undue burden and strain upon the manpower of the police department. So through the facts, this paints a picture of a group that is completely lawless and out of control. Okay? So then you move after that, you start to move into, there are more facts about the, looking on the second page, starting at page 3, 10 of the U.S. Reports version. 5 of the 8 petitioners were served with copies of the writs. They held a press conference. Their statement was distributed, declaring their intentions to disobey the injunction. Next, that night, a meeting took place at which one of the petitioners announced the injunction that we are going to march tomorrow. Meetings sponsored by some of the petitioners were held that night and the following night, where calls for volunteers to walk and go to jail were made. And so you have them, first of all, having this unruly gathering contrary to city ordinance, and then you have the city of Birmingham making repeated efforts to get them to comply with the ordinance, and them repeatedly the protesters repeatedly announcing their intention to go forward anyway. So the legal theory here is what? What is the basic legal theory here? What legal claim is it that the court analyzes? Yeah, you son?
I think violation of city ordinance.
Yeah, it's just a simple violation of city ordinance. The question is simply, did they get the necessary permits or did they not get the necessary permits? Which is interesting because the Supreme Court generally doesn't get involved a lot on permit violations, but they did here. So you've got your factual narrative, which is a story about a lawless mob intentionally flouting the laws. And your legal argument focused on whether or not this group of people violated the city ordinance. Now, does the story, the narrative, make the legal theory more or less believable? Yeah, Joan.
Much more believable.
Exactly, makes it much more believable. We don't have any trouble believing that this group of lawless individuals would not bother themselves with a city ordinance, that they clearly act above the law and outside of the law. And so we don't have any trouble. So the narrative primes us to accept the legal analysis. Okay, so now we're going to go to Shuttlesworth. Same case, same facts, same author, different story. So now in 1969, the exact same case comes up in front of the Supreme Court. And now, what is the narrative? And when you answer, I'd like you to take a minute, if you would, and find specific language. Rather than summarizing the narrative, find some specific language to share with us all about what this narrative is. How did they tell this story? Yeah, Nikki.
It was set up to describe it as non-confrontational, really.
Okay, in what way?
In the facts, the way that it's stated, it says that the marchers stayed on the sidewalks except at street intersections, and they did not interfere with other pedestrians. And then it goes on to say that no automobiles were obstructed, nor were traffic signals disobeyed. So I feel that just in putting the facts of it, it's a very non-confrontational description.
Yeah, absolutely. Ken.
Yeah, I was gonna basically say the same thing, but just to add on that, like, even though that it did seem to like try to say that it did get a little bit out of control by saying the marchers moved along a crowd of spectators and the spectators fell in behind them. Mm-hmm. Even though like they wanted to make it seem like there might have been a little bit of a, like confrontation, but it wasn't really as bad as it's intended to be.
Yeah, exactly. Joan?
Yeah, it sets it up in the beginning. He mentions immediately that they were ministers.
Mm-hmm.
They worked in orderly fashion. And then it goes on why they were marching, which wasn't really done either.
Yeah, exactly. So we've got an orderly fashion, 2 abreast for 4 blocks. Okay. Marilyn.
That's actually what I was going to say, that they mentioned it was only 4 blocks. They were only allowed to march 4 blocks. Yeah.
Yeah, and so notice these 2 opinions are just brilliant. And notice, before we start talking about the priming for the argument, notice the structure of the story. It starts out with the protagonist. The petitioner stands convicted for violating an ordinance of Birmingham, Alabama. Okay? And so it's the same story, but it sounds very different. And I think Shuttlesworth and Walker are some of the best evidence that you can take the same set of facts and tell 2 very different stories leading to 2 different legal conclusions. And in fact, these stories are told in such a way that the legal issue is different in each of these cases. In one, it's a violation of a city ordinance. In the other, it's the constitutionality of a city ordinance. Those are 2 very different legal issues, and they get analyzed differently and lead automatically to a different conclusion. Notice also the information that's provided that's not legally relevant. Remember, we talked about in Broomfield and Clark that both justices used information that wasn't legally relevant. Here, I think the non-legally relevant information is used very well and very subtly in that it's woven in more and it seems more relevant, whereas the stuff with Darius Clark, it doesn't seem relevant from the beginning. And also the stuff about in Broomfield about the victim's son, that doesn't seem relevant. I think Justice Thomas could have set that story up in a way that it seemed more relevant. I think Justice Thomas could have made the legal relevance more clear, and I think it would have packed more of a punch because it would have seemed less overtly emotional, but would still pull at you. Likewise, I think the stuff about Darius Clark could have been woven in a way where it seemed more legally relevant, or at least seemed to provide relevant context, instead of being so overtly emotional. And so I think the court in Shuttlesworth and Walker both do a really nice job of weaving in irrelevant but emotional information very effectively. So they walked in an orderly fashion. The purpose was, and so it's just that one little statement that's not legally relevant. The rest of it's all relevant. Okay, and so then you've got, okay. So remember we talked about the structure of a story being order, disorder, chaos, resolution. So those first 2 paragraphs are order. Here's what they were doing. Here's what they were doing when the antagonist came along. At the end of 4 blocks, the marchers were stopped by the Birmingham police. And so now you've got the equilibrium of the protagonist being disturbed by the antagonist. And you've got a clear vision. I'm sure if we could all, project the movie that we have in our head, I bet they would be somewhat similar on these facts. You have, and like it doesn't say, for example, that the Birmingham police were in a row with nightsticks, but that's what I see. That's what I see. They were stopped, and I see, like, that's the image I get. It could have been police officers going, excuse me, pardon me, but that's not that's not the image that the language evokes. Okay, and so then what is the legal theory in this case? Anybody, what is the legal claim? Yeah, you son?
I guess the First Amendment violation regarding freedom of speech or kind of demonstration. I'm not sure.
Assembly is, yeah, that's the word you're looking for.
Yeah.
The question is, does the statute violate the First Amendment guarantee of the right to assemble? And the right to, what kind of assembly are we guaranteed? The First Amendment guarantees us the right to assemble in what manner?
Peaceful.
Peaceably assemble. And so have we not got a description here of a peaceable assembly? Okay. So they didn't touch, in Walker, they didn't touch the right to peaceably assemble. They didn't get to that. But you can see how the facts were primed to divert from that, to say even if they have the right to peaceably assemble, this wasn't a peaceful assembly, and so we don't even. So it's written in a way to take that First Amendment right sort of out of your thinking, because it sets up not a peaceable assembly. So we have the right to peaceably assemble, and we have a very nice description of a peaceable assembly here. And so then the court ultimately concludes that this ordinance does violate the Constitution. So again, you're primed by the facts to accept the legal analysis. Okay, and that's why we started the course back at the very beginning, talking about legal theories and factual theories and how they pull together for a theory of the case. So you construct this theory of the case, and then this is the way you execute it. You have your narrative that primes your analysis, and then both of them together prime your reader to accept the conclusion. And so that's how theory of the case works. Theory of the case is your first iteration of bringing all that together, and then this is the way you execute it. Okay. Are there any questions about either priming within the statement of facts, or priming your argument with the statement of facts, or priming your conclusion with the argument and the facts together? Yeah, Joan.
Not directly about that, but what changed in Justice Stewart's heart that he made such a different description of the same event, other than the intention?
That's a great question. What do you guys know from history? What was changing? Yeah, Marilyn?
I think you were seeing more images from 67, between 67 and 69, you were seeing more images of police attacking protesters, chasing them with dogs. You saw the injustice of it. And I think before then, maybe he wasn't aware that it was that bad, or that these cities were going that far in basically oppressing.
Yeah, I think because the Civil Rights Act was passed in 1964. And so Walker was still 3 years out from the passage of the Civil Rights Act. And so, that can't be the explanation. But between 67 and 69 was when the Vietnam War was really ramping up. And you were seeing a lot of protests around the Vietnam War. And those weren't just civil rights protests. Those were war protests. And so who was involved? Where were a lot of those protests taking place? Yeah, Marilyn?
I think they were mostly on a lot of university campuses, very high profile. Something that touched an academic or a judge.
And this is a point that I think has been controversial. I don't know that it's very controversial at this point, but there's a critical race theory of intersectionality that rights tend to be extended not because of the injustice of not extending the right. If it were the injustice of not extending the right, Walker would have been decided the same way as Shuttlesworth. But not when the injustice becomes apparent, but when the injustice begins to affect the power class. And so when those in power begin to experience an infringement because of the injustice, then something gets done. And so I think what we're seeing is now white students at universities were being brutalized by police officers, arguably. Those were the images that we saw. And so all of a sudden, this relationship of police to protesters was impacting white academics, white judges, white students in a way that it never had, bringing the issue into sharper focus for many within the power structure. And so what was once seen as just trying to maintain order was now seen as an abuse of power and a violation of the Constitution. And so that's one explanation for why such a dramatic turnaround in such a short time. It was such a volatile time in the country. And so I think the courts were trying to curb executive power, basically, at that point. Yeah, Joan.
Yeah, and just when you said look at history, of course, in 1968, right in between, Martin Luther King was killed.
Yes.
So.
Yes. Yeah, in April '68, King
must have.
Yeah, I think Marilyn's absolutely right that it's the violence of the protest and the images that we were seeing on TV that really made a huge difference in how things were handled, because peaceful protests seem like a nuisance until you run up against a violent protest, and then you want to encourage people to go back and walk in the streets two abreast for 4 blocks for a while. Yeah. Okay. So excellent work and analysis. So what I'm going to do now is I'm going to put you in your groups, and here's what I would like you to do. So I'm going to read these out to you a couple of times so you can write them down. So here's what I want each of you in your group to do. I want you to describe briefly your narrative. Basically, and when I say briefly, I mean a few sentences. What is your essential story? And remember, in Walker, the essential story was an unruly mob who would not listen to any reason, who would not follow any rules. And the essential story in Shuttlesworth was peaceful demonstrators trying to exercise a constitutional right, peaceful demonstrators seeking a peaceful solution to a significant societal problem. Then I want you to describe briefly your legal argument. And so again, in Walker, to briefly describe that, you would say the protesters violated a city ordinance requiring permitting. And in Shuttlesworth, a brief statement of legal argument would be the Birmingham City Ordinance violated the First Amendment guarantee to peaceably assemble. Then explain how the narrative that you've constructed primes your argument. How does the story you tell make your legal analysis more or less likely? Just as with, it's easier to see an unruly mob violating a city ordinance. It's easier to see suppression of a peaceful mob. It's easier to see suppression of a peaceful parade as a First Amendment violation. And then after you've described those things briefly to your group, get some feedback on whether that makes sense, whether they do fit together, whether that priming works the way you think it does. And if not, what might work better? What suggestions do you have for one another? And so you guys have basically 45 minutes to do that. These are significant discussions. They're going to take some time. I am, as I always am when you guys do group work, I am sitting right here. So if somebody needs to pop back into the main room and ask me a question, please feel free to do that. But it should take about 45 minutes. That gives you about 10 to 15 minutes each to go through fully your theories and how they fit together and how they prime, and to get feedback on them. So that should be just enough time. If you finish early, come back into the main room. We'll talk for a minute. If I'm satisfied that you're finished, I'll be happy to cut you loose. And of course, if you have questions, just let me know. I'll be right here. Okay, I'm going to open all the rooms. Not me.
Professor?
Hold on.
Okay.
Okay.
Hey, so I have a question.
Okay.
So I'm kind of like, I spent a lot of time on my fact section this weekend, and I'm trying. So originally I had the Rateful as the villain, and he was the horrible person. But I'm definitely going to go for the statute and the legislation being the villain, because it's unclear, and really anybody could steal work because of the statute being unclear and people being able to register it properly. But so I'm obviously limited to the facts that are in the record, and are we supposed to be annotating or going through this with because my statement of the facts includes the procedural history. Are we supposed to be annotating the procedural history as well, or no?
Yes, I went ahead and added the procedural history because, first of all, it is a place where you can be persuasive depending on how much detail you provide about the basis for the lower court's decision. Mm-hmm. So yeah, the short answer is yes. Okay.
So, I mean, and the way I've always had the procedural history is I had that first in the statement of facts, and then I talked about the narrative or the actual facts.
Right.
Because it's very statute specific, it just feels very unnatural to be talking about the statute when I'm talking about kind of the sequence of events that happened. And, I kind of want to like throw in, hey, trial court ruled this, and now I don't know. I'm having a hard time, basically.
So, yeah. So if you want to draft the narrative in a way that makes the legal argument more plausible. And so to do that, first of all, your legally relevant facts there's only a very few number of legally relevant facts. And so the facts part of your statement may ultimately end up being pretty short.
Yeah.
Because you want to make it seem more like this is really a legal problem. Mm-hmm. This really isn't, no, he didn't do anything wrong here, but neither did my guy. And so.
I just thought of an idea too.
Okay. And so, but here's the thing. So if you have that really short statement of facts, you want to annotate that. You want to say, this is why I did this. This was, and describe the strategy.
Okay. And I'm also adding, because I have one of my paragraphs, seeing the success of his stolen work and fearful of the potential diminished sales. He, followed the requirements outlined in the statute by doing X, Y, Z. But I'm just adding a note for myself saying, hey, well, not only fearful of Rayful, but also anybody else, because that's really what the problem is.
Absolutely.
Okay.
Absolutely.
All right. Okay. All right, cool. I'm going to jump back. Thank you.
Okay, great. Oh, everybody's back. Sorry, I was in a room. I don't know. Did it say I was in a room?
Nope.
Oh, I'm sorry. I was just gone. No, I was in one of the breakout rooms. I'm sorry.
Don't worry.
Okay, so first, Nick, Joan, and Ken, you guys are done, or you have questions?
We're probably done.
Okay. So tell me, you guys have Keg's list, is that right? Oh, no. You guys have the
Bolson.
Works at the,
Bolson.
Okay. So do you have any questions about that, about how to prime your argument with your facts?
We're all very frustrated with the way we wrote our original brief.
Well, yeah, I mean, but you wrote it at a beginner level, and now you're moving on to a more intermediate and advanced level. And so, so that's another reason why it really works to have.
But some of the instructions that we got in the prior class also are kind of contradictory to this class, because we were told to when you talk about, for example, the process, the legal
the procedural
history that needed to be really factual. You couldn't really.
Yeah, and here's the thing. I don't disagree with that. It needs to, but I'll modify it. It needs to appear very, very factual.
Yes.
there is information in the procedural history. So, for example, let's say that the lower court decision supports your position, that you are defending the lower court's decision and you think it should be affirmed. So you want to say that the lower court ruled this way and the basis for the decision, and give the rationale, even though the rationale isn't actually part of the procedural history. It seems like it. It seems relevant, and so you want to give more detail. Whereas if you lost at the trial court level, you just want to say that the court ruled in that, ruled for the other party, and then just move on to your facts.
Could you go so far as to say that the court made a mistake in that section, or you should
not in that section?
Okay.
No. But by providing more or less detail, every chance that you have to push part of your agenda, you want to do that. And the places where sometimes it's the most effective is where it seems the least persuasive. Mm-hmm. And so the procedural history needs to appear purely factual, and it is purely factual. Even if you include the basis of the lower court's opinion, that's still that is what they did. But the thing is, strictly speaking, it really doesn't matter why they did it. Mm-hmm. Particularly for cases that are de novo, and a lot of these are, it really matters not one bit what they did.
So for something like that, like you wouldn't say that like the court overlooked something and then like kind of explain it, or that's going too far? Not
in the procedural history now.
Okay.
That does
goes to your argument.
That does, yeah, absolutely. It can't be an argument. Yeah, you don't want to comment on whether they were right or wrong. You just want to say what they did. But the more detail you give about what they did, the more attention the reader pays to what they did.
So we should just since we were the appellant, we lost in the lower court, we should just say that, this is just what happened. Give no kind of facts, just kind of just brush over it a little bit.
Here's who filed the initial complaint. Here was the response. Here was the court's ruling.
Okay.
Here we are.
Okay, thank you.
Yeah.
Ken almost convinced us of his side of the Morton case.
That's awesome. That's awesome. Marilyn, Nicole, and Karina, do you guys have any questions?
I think we're okay.
I actually had one question though. The legal theory, do you still want us to keep it at 10 words or?
No. Okay. It doesn't have to be. No. And the legal theory, of course, or not necessarily the legal theory, the theory of the case, which combines your factual and your legal theory together. That's a good thing to have. And of course, I would expect that after all these weeks that you're sort of constantly refining and changing. So, but the theory of the case makes a really nice intro statement to your summary of argument.
Okay.
Yeah. Any other questions? Okay. You guys get to go 7 minutes early. Don't use it all in one place. I'll see you tomorrow night.
See you tomorrow night.
Bye.
Bye.
Hey, Jackie, do we just log out or wait until 8:10? What are we doing? Oh.
Hi.
Hi. Do you guys have any questions?
It's a lot of writing. But no. In theory, everything makes sense. Everything is our arguments.
Right.
It just, you need to really pick those words that would really one word would just like now, one will bring you to that point that you want to make.
Right. Yeah. Okay. Well, you guys are free to go 5 minutes early. Don't use it all in one place.
Bye, Professor.
See you tomorrow night.
Have a good night.
Thank you. You too. Hey guys.
Hi.
So did you guys have any questions?
No, I don't think so. I don't. Oh, is it just our group or is everyone here?
No, 2 groups have already finished and gone.
Okay, I wasn't sure if you were asking the whole class or if I was just jumping out.
No.
I don't think so. It was really helpful. I think anything that we had, we kind of worked through as a group together.
Okay, great. Okay, I will see you tomorrow night.
Great. Thank you. Bye.
Bye.
Professor?
Uh-huh.
Can I just stay on with you for a minute?
Yeah.
Okay. I'm having some trouble with my facts.
Okay.
We looked over my facts last week and everybody decided they were too lengthy.
Right.
So I tried to cut them down as much as I could.
Okay.
And I think that everything I have in them is necessary to the story.
Okay.
My only issue now is my annotations. Because am I going to say everything is priming? If everything's supposed to be priming, am I supposed to annotate every paragraph why it's priming?
I mean, everything isn't necessarily supposed to be priming, and like you don't necessarily need to annotate every paragraph as priming.
Okay.
But when you start, for example, talking about so let's say I was going to annotate the facts in Shuttlesworth.
Okay.
And so I would sort of at the first paragraph, I would say, I'm using, I'm using the literary convention of starting with the protagonist perspective by introducing the petitioners first. And then the next paragraph where it talks about the event itself, I would say there are a lot of things I could talk about in that paragraph. One of them would be I am priming the reader here to accept the legal theory by telling a story of a peaceful assembly that makes it more likely that a First Amendment violation occurred. And so then let's say you had 3 paragraphs about the peaceful assembly. You would need to annotate, you would need to give that same annotation for each paragraph. You would just give it in the first paragraph.
Okay.
Okay. So I guess when you sort of introduce a new technique when you introduce or you shift techniques, then you might want to give an annotation, but you don't have to do it every single step along the way.
Okay. Okay, I think I'm all right, but there's one other question. Ryan had said that you mentioned that we need to annotate the procedural history.
If you change the procedural history and if you do anything to make it more persuasive, yeah, you need to do that.
Okay. All right. Okay, I think I'm all right.
Okay.
Thank you, Professor.
You're welcome. I'll see you tomorrow night.
Thank
Okay.
you.
So we already talked. Do you guys have any other questions?
Oh, no, we were just going back to the main room.
Okay. I'll see you tomorrow.
All right, okay, bye. I lied, I think.
Okay.
I was going to send you an email. I just figured it's easier to talk to you now. I had it all typed up. It's about Sunday's class. If I'm not able to make it because I had plans already set, there was engagement. Is that a problem?
It's not. It's not going to count as an absence because the only way I would count a makeup as an absence is if everybody unanimously committed to be there.
Okay.
Then I would count it. But I don't count it as an absence. It will be recorded. I have full faith that someone will remind me to record. And as soon as the class is over at 10:40, I'll convert it and upload it.
Okay.
And so you should be able to get to it sometime Saturday afternoon or Sunday afternoon or evening.
Yeah.
If you want to get to it right away. So yeah, but it's not a problem. And if you have questions after you look at the video, just let me know.
Okay. Thank you so much, Mr. Martin.
Thanks, Dominic. See you tomorrow night. Hey, Stan.
Hi, how are you?
Good. Did you have any questions or are you good?
No, I actually didn't have a question. I thought that my partner broke out to the main room.
He did. He's gone.
Okay.
Okay.
Great. Thank you.
So I'll see you tomorrow night.
Yeah.